Good morning. The June 12, 2026 meeting of the Mackinac Straits Corridor Authority is called to order. The record should reflect that all three of the authority members are present. The first item on the agenda is, and I'll take these jointly, approval of the agenda and approval of the February 27, 2026 meeting minutes. I'll entertain a motion for approval.
I make a motion to approve.
All in favor, say aye. Aye.
Aye.
Both the agenda and the February 27 meeting minutes are approved. We are on to business, and the first item under that is project permitting updates, always our favorite topic to discuss. The first of which is the status of a Michigan Public Service Commission permit and the appeal of that is sitting in the Michigan Supreme Court. Devin Sullivan, the counsel for the...
Pause real quick, sorry, we do not have
Yes.
audio on mine.
Oh,
So we are efforting, I'm sorry.
you want me to pause?
Yes.
Okay. The record should reflect that we've had some audio technical difficulties in transmitting the meeting, but my understanding is we will at least have an audio recording of the meeting preserved, if not visual, although visual is less of a requirement for purposes of maintaining a public record that encompasses the entire meeting. Is that correct?
Yeah.
Okay. So with that, we will hand it back to Devin Sullivan for an update on the MPSC permit.
Thank you, Mr. Chairman. As discussed at prior meetings, the Michigan Supreme Court granted leave to hear appeals of the Michigan Public Service Commission's order, which granted Enbridge's application to construct a replacement segment of Line 5 within the tunnel. Since our February meeting, the court heard oral argument on the leaves to appeal on March 11th. Video of those oral arguments is available on the court's YouTube page. The Supreme Court has not yet issued an opinion. My expectation is that will be issued by the end of July, likely towards the end of July.
Okay. Any questions of Devin with respect to the MPSC permit? All right. The next two items, Michael Belligan, an environmental specialist at MDOT, will present with respect to both the Army Corps of Engineers environmental impact statement and Eagle, a couple different Eagle permits.
Thank you, Mr. Chairman, board members. An update on the first part with the U.S. Army Corps of Engineers permit. Since the last MSCA board meeting on February 27th, 2026, the 30-day public comment period for the final environmental impact statement initiated on February 6th, 2026, ended on March 9th, 2026. The Army Corps is currently working to complete their Section 106 historic properties review, in addition to awaiting an Eagle permit decision. That update will be coming in a moment. Due to potential adverse effects to historic properties, a memorandum of agreement, or MOA, with the external groups is being completed. Now, as a clarification on that point regarding Section 106 MOA, in permit reviews involving adverse effects to historic properties, the Army Corps would typically conclude their Section 106 process by filing a fully executed, meaning signed, memorandum of agreement with the Advisory Council on Historic Preservation prior to completing a permit decision, in this case, which would be issuing the ROD, or the record of decision. Then the memorandum of agreement would be placed in the ROD. In this instance, the project is an energy-related project subject to Executive Order 14156, declaring a national energy emergency from January 20th, 2025, and as such, Army Corps used applicable emergency procedures in its review. The Army Corps complied with Section 106 using 36 CFR Section 800.12B2 emergency situations, which does not require a memorandum of agreement or other agreement document. Despite the elimination of these requirements, U.S. Army Corps still plans to fully execute, meaning sign a memorandum of agreement with the groups in the coming weeks prior to completing the ROD. All is to say that there's an exemption from this requirement in the, resulting from the coverage of the executive order, but they're choosing not to take advantage of that exemption in this case. The record of decision, now expected to be published in summer 2026 per Army Corps, would conditionally approve or deny the pending Section 10 and Section 404 U.S. Army Corps of Engineer permits.
Thank you. I appreciate the update on that. Just for the public, when you say historic properties, it also means archaeological
Yes,
effects. I
yes,
just
thank
want-
you
I
for
mean,
that, above and below ground.
So, yes, I just want the public to understand.
Probably more appropriate to say cultural resources,
Correct.
like protected resources.
Thank you.
Other questions?
No.
Okay. You can continue with the Eagle permits.
Thank you. Moving on, I'll speak to Part 31 first, the NPDES permit, National Pollutant Discharge Elimination System. The draft Part 31 permit was sent to Enbridge for their pre-public notice review on March 5th, 2026, with Enbridge finalizing their review and reaching concurrence with Eagle and regarding the language on May 5th, 2026. That same day, the draft permit was sent to tribal staff for their review. Currently, the NPDES permit is on advertised public notice. The public notice period began on May 19th, 2026, and it'll run until 11:59 p.m. on June 30th, 2026. There's a combination virtual public meeting and hearing scheduled for June 18th, 2026 at 6 p.m. Anybody can register to attend that meeting from the public. The NPDES permit reissuance is required to be decided prior to October 1st, 2026, the end of fiscal year 2026. And as we noted in the past, there is currently in place an approved NPDES permit. This would be a reissuance of that permit. Any questions on that?
Just one, the June 18 public hearing for that NPDES permit. Do you have the specifics as to where and when that public hearing? Well, it's obviously on June 18, but the time and location?
At 6 p.m. and it's a virtual
Okay.
meeting only. I don't believe that there's any availability for in-person attendance.
Okay.
Moving along to the Part 303, wetlands, and Part 325, Great Lakes submerged lands permits. The Part 303, 325 combined permit application is currently still under review by Eagle staff, with additional cultural survey work being completed by Enbridge since the last MSCA board meeting in February. The previous review deadline of March 15th, 2026, as of that meeting, is now extended to the statutory deadline of July 16th, 2026. Although Eagle's current Clean Water Act Section 401 certification deadline with the Army Corps is about a week earlier on July 7th. That's a separate certification process that has a deadline of about a week earlier, as I said, on July 7th. Eagle will make a decision on the permit application on or around those deadlines per Eagle response, so early July expected decision.
Okay. If I can get a clear understanding of the sequence, the U.S. Army Corps' record of decision will not issue until the Eagle permits, a determination on those Eagle permits has issued. We anticipate an Eagle permit issuance decision as of July 16 at the latest,
Yes.
and then a record of decision issuance by the Army Corps on the environmental impact statement sometime after issuance of the two Eagle permits.
Yes, that's my understanding.
Okay. Any other questions for Michael?
Just one also clarification that the MOA needs to be executed also.
Yes.
So it's not just the permits, it's the MOA for the Section 106 in addition. So there's a few hurdles
For the MOA, yes, it would need to be fully executed. Army Corps said they plan to fully execute the memorandum of agreement in the coming weeks as of communication several days ago.
Okay, very good.
That being said, like I mentioned, there's no legal obligation for them to do that, so I don't know what circumstance that puts them in, should that signing be unfeasible for whatever reason. But their intent now, their stated intent, is to execute that agreement prior to issuance of the ROD.
Thank you.
One last item for the Part 303, 325 permits. I don't want to forget, as I mentioned, July 16th, 2026 is the statutory deadline for these permit applications to be resolved, and there are no further extensions available as such. So in the past, there have been extensions that have been legally obtainable. Now that's no longer the case. That June 16th is a hard deadline.
July.
Or sorry, yes, July. Thank you.
All right. Thanks.
Yeah, thank you.
Next item on the agenda is project document updates. Devin Sullivan, the Assistant Attorney General to the Authority.
Thank you, Mr. Chairman. At our February meeting, we discussed the status of two project documents, the geotechnical baseline report and Enbridge's contract with the Mackinac Straits Partnership, the contractor that has been retained to construct the tunnel. The geotechnical baseline report was produced to the authority staff just after our last meeting. As a reminder, the tunnel agreement required Enbridge to prepare two reports with respect to the geotechnical work that was performed in the Straits, a geotechnical data report and a geotechnical baseline report. The data report has been publicly available on our website for some time and has all of the data and information regarding that geotechnical work. The baseline report doesn't include additional data or information. It's a summary and an analysis of that information that Enbridge had prepared largely as part of their contracting with their contractor. Staff has reviewed the baseline report and confirmed that it's consistent with our understanding regarding the geological conditions and the data report. Many of the items that are discussed in the baseline report are specifically addressed in the project specifications to ensure that they will be appropriately handled during construction.
Anyone have questions with respect to that?
All right. Last week, Enbridge provided us a redacted version of its contract with the Mackinac Straits Partnership for the construction of the tunnel. The tunnel agreement provides that the authority has the right to review the contract to ensure certain provisions are included. Our understanding from Enbridge is that it has left those portions of the contract unredacted and redacted the remainder of the contract in exhibits. Staff is in the process of reviewing this version to determine whether all of those required provisions were in fact left unredacted, and we'll discuss further at the August meeting once we've completed our review.
Is there any time element involved for purposes of complying with the underlying agreement that we have to make a determination as to whether all of the necessary conditions in the construction contract have been included?
No, there's no deadline in the tunnel agreement either for when the contract was provided to us or when that determination is made.
Okay. Questions with respect to the construction contract?
Just a question on the review time. Do you think it would be ready for our August meeting, or are we thinking longer than that?
No, it will certainly
Okay,
be ready for the
okay,
August
thank
meeting.
you.
All right, I think we're on the next agenda item, which is a general project update from Enbridge.
Good morning. Anna Mooney, Government Relations for Enbridge. I just wanted to update or highlight a couple, I guess, items that were just previously discussed by Michael and Devin. Starting with the permitting updates, just to, again, put a finer point on a couple of those. As was mentioned I'll start with Eagle, with the state. When I was here before you in February, we had just had a request from Eagle for additional survey work. I'm really about the 11th hour of kind of the permitting process or review process. So we were able to turn around a survey plan, conduct those surveys in the last month, once the snow left the ground up here and conditions were ripe for that. So we were able to complete the survey work, complete our summaries, and submit those to Eagle. As Michael mentioned, that July 16th statutory deadline is the 1 year from when the application was deemed complete, which was July 16th of 2025. So that's where that date comes from. And I think just to further clarify too, the U.S. Army Corps' work that's complete on the environmental review and their final EIS that was issued, their record of decision or their ROD cannot be issued until that 401 certification is issued by the department. And so we anticipate also, again, just that the MOA that was talked about on the 106, that will be, the executed MOA will be part of the record of decision that the Corps issues whatever time period right after Eagle makes a permitting decision. So that's, again, that survey work was completed. We remain, in communication with the department and interested parties to ensure they have all the information that they need to complete the review and make a decision on that permit. We do anticipate, again, as Michael indicated, that mid-July deadline. They have to make a decision by July 16th. So, and we have every indication that they will. To move on to the NIPD's permit that was mentioned as well, just again, those dates were given on the public comment period. It is a virtual meeting next Thursday evening. I know that there are opportunities to register right now if you wanted to speak or submit written comment to the record, and the record is open until, as Michael said, the end of June, so June 30th. And then also just to put a finer point on the fact that we do have a current valid NIPD's permit. We did apply in a timely manner. And so therefore, if we had all permits, we'd be able to act on this one. But we will be reapplying for this. It's a 5-year permit, and we will be reapplying for it for the life of the project, in perpetuity for the life of the project. So that's, and I think, again, the distinction that the NIPD's permit is a draft permit that's been issued that the public and interested parties are asked to provide comment on that draft permit. I believe that's all the additional points that I was planning to make. Any questions for me or topics I've missed?
I have a couple.
Okay.
First, I think we have a shared understanding that under the agreement, commencement of construction is triggered when all applicable permits have issued. And so we have, I think, either 3 or 4 outstanding items before commencement of construction would trigger. The 2 Eagle permits, the record of decision by the Army Corps, and then the 4th, I'm not sure if I put this in that category or not, the Public Service Commission permit and a determination by the Michigan Supreme Court with respect to that. My question is, let's assume there is a judicial challenge to that. Presumably, we're going to find out in the next month or so whether the judicial challenge to the MPSC permit is going to be successful or not. So let's leave that one on the side for the moment. If there are judicial challenges to the other permits, does Enbridge envision that those judicial challenges would potentially delay the triggering of the commencement of construction within 180 days deadline? And if you want to confer with legal counsel and contemplate an answer rather than giving it off the cuff, that's entirely fair to you to do that. You don't even have to give it right now, but it's something as we get closer to these various benchmarks being accomplished that I'd like to know the company's position on.
Okay. Happy to do that. I can tell you off the cuff. I'll give you
Go ahead.
some answer to that. We do, as you said, we acknowledge and anticipate that permits, if permits are issued, they will be contested. But we will have a valid permit when that is, I'll just be optimistic, when that is issued, should that be issued. And so I can get you a more formal answer of what that timeline looks like, and maybe even by the August meeting, we'd have a little bit more definitive potential on, well, we'll know at that point where we are with Eagle for sure, and with the core. And then, as you said, MPSC is a bit of an outlier because that timeline is, we actually are thinking more like fall, but we don't always try and guess what the Michigan Supreme Court timeline is. So,
I have the same issue on
Okay,
entirely
yeah.
different matters, but.
okay. So anyways, a short way of saying that, yes, we can get back a more definitive answer for you, but we would have valid permits if those are issued, even while they are contested.
Okay. As a sub-item to that, or a corollary to that, the Michigan Public Service Commission also contemplated an additional risk submission or evaluation to the authority as one of the conditions that existed in that permit. Can you give an update? And again, I don't mean to pop you with these things without having identified them in advance. So it's something that I think we could have a more thorough discussion of in the August meeting.
Okay.
But, so if you want to just insert place marker here and respond there. But at some point, I think, should the MPSC permit be approved judicially by the Michigan Supreme Court, or not reversed, there would be additional work in terms of an evaluation of risk that was contemplated as one of the conditions. And I think August might be an appropriate time to more thoroughly discuss that obligation for both of us.
And if I'm recalling too, it's prior to construction that risk assessment be issued, right? Correct?
I
Yes.
think so, yes.
Okay. Yep. I will put a note in there for the next meeting then.
Okay. That's all I have. Do either of you have questions for Enbridge?
No.
Okay,
Thank you.
thanks. Next up, I'm sorry, I did have one more thing. And it was the next agenda item that reminded me, that was our project advisor budget report, which reminded me, Enbridge is tracking, I understand, the appropriations process where our request for additional funding to support the contractors that the authority contracts with to manage from the authority's side of this project, our obligations. In tracking that, can you give me your understanding as to where the legislature is on that budget request, and whether the company has taken a position in support of that request for additional supplemental appropriations?
Sure. It's my understanding that the, not to give the whole budget process, but the Senate included it in their recommendation. The House did not. The House and Senate are now in a period of negotiating all the items within their budget, this item, as you said, being one of them. I'm not privy to what those negotiations are. I don't know that those chambers have discussed targets to meet yet. And I also, as much as I wouldn't speculate on the Supreme Court, I wouldn't speculate on the legislature's timeline for getting a budget done, although I do hear it could be in the next month or so. We have, if asked by members, especially because it's not in the House budget right now, if asked by those House members, have been educating them on what we believe those dollars are for and why those are necessary for the state to provide their role of oversight for the tunnel project. So aware, tracking it, not sure, can't speak to exactly where it is, where that particular line item is, as those budgets are being negotiated. But happy to engage again with any members that have questions or ask about it or want to better understand what those dollars are used for.
Okay. And Enbridge has been supportive of that appropriation in the discussions with House members?
Yes, I don't know that we've not taken a formal position, as we typically would not. These are, state dollars for the state to oversee the project, not to be for building the project, right? So we have not taken a formal position. If members have have had questions around what those dollars or, again, how the state performs a role of oversight, I have directed back to MDOT and staff as it is your, budget item to, to advocate for.
Okay. Thanks.
Thank you.
The next agenda item is the project advisor budget report. Stephen Ward's up.
Right. Good morning, Mr. Chairman, Board. Stephen Ward, the MSCA Project Manager for the Line 5 Tunnel Project. So I wanted to quickly give you an update on the funding for this project, and it's on our budget execution slide. And so what I've added to this time is we had a little bit more executed budget. We're up to 1.735 million actually executed and on advisors, and another 228,000 on internal expenses, which leaves us about 2.526 million remaining in our appropriated budget. Now, that is not including the encumbered, which is the next block on that. On the budget encumbered, I did add in our new ORC contract into that, which was $593,681.30. And I also just put the internal expenses through FY27. I did have it through FY28 earlier. I put it to FY27 because our burn rate's about $150,000 a year for all of our expenses to run the program internally, which leaves us about $884,000 for next year to do the next ORC contract, which right now we're only going to do, you're going to see here in a minute, the task order 1, which only takes us out 1 year. If we go into construction, that task order is going to get much beefier. It's going to be a lot more involvement. And so we really do need that $4.1 million plus up in order to do the next phases as we move into construction. And we've kind of already talked a little bit about that budget, so I'm going to pass on that one. Are there any, I did want to, on the next sheet, it's got all the contracts, and I did want to make sure there was one mistake in there. The Delve Underground contract term, it wasn't 9/30/2028, it's actually 9/30/2025. That was for the Delve Underground contract on the specifications. That one has expired, and now as we move on to our ORC, the ORC, RS&H, Matt Chenoweth is with us today, they will pick up those duties on the specifications committee. So they will be picking up those duties because Delve will only be doing the QA/QC because we saw that as a potential conflict of interest. We dropped them from the specifications committee, and they're only doing the QA/QC.
Thank you
right.
for that clarification.
Yep. All right.
Any questions of Stephen with respect to the budget report? Okay, you can continue with contract updates.
Okay, great. So as we talked a little bit about their independent quality assurance contract, which we do have with Delve, that is a sort of a complicated one. They have a contract with Enbridge, and Enbridge is actually the one that does pay them for their services, but we also have a contract with them because they are our IQA. They work for us to do IQA for us. Now, they don't actually do the testing, but they're observing all the testing. They're there for everything that goes on. They review all the submittals, and they do that for us, and they report back to us. That contract is available today for signature, and Chairman, that's in front of you, so we're hoping to get a signature on that one today. And then as we move forward, we're going to move into there'll be an amendment to this one as we move into construction. So there'll be basically a phase 2 to the IQA that will take us through the construction phase. This is all the pre-construction phase that you'll see in the IQA that you have to sign today. But then as we move on, we're going to do a new one, and we're almost done with that one to move forward with the construction phase once we get to that. And then the second one is the owner's representative consultant contract, the first task order pricing approval. The task order pricing is all in there, so you'll see the bid, and that did come in at $593,681.30. The contract is all ready to go. We've been working with RS&H and the contracting folks, so as soon as this board gives the approval to do that, that we can move forward with that dollar amount, then we will finalize the contract and get it over to you, Mr. Chairman, for signature. And I think that is kind of where we stand on those two.
Just a question on the Delve contract. Do we have the list of the person, because the board is supposed to approve the personnel, the list of personnel for the Delve contract?
Okay.
Is that in here?
I will have to validate whether it's actually in there. I can get those names. We do have the names of who works on it, so I will add that to the list, make sure we have that. If it's, I'm not sure if it's included in the contract or not.
Okay, because when I skimmed through the contract and everything else, there's a piece in there where they're supposed to have certain background checks and everything else, and then the board is supposed to
Yeah.
approve it, so.
I think with respect to that, the board could delegate that authority to Mr. Ward if they choose to approve the contract and authorize him to then approve the key personnel for the contract. The contract speaks of the MSCA, but doesn't necessarily always distinguish between the board and staff. The contract here is a little bit tricky to prepare because it has to include a lot of the standard MDOT provisions that are then a little bit challenging to apply to our particular situation. So I think if the board is inclined to handle it that way, you could authorize
So-
Mr. Ward to do so.
Because he is, I mean, the contract talks about the MSC, project manager, and that is Mr. Ward, so, okay, I understand what you're saying. Thank you, Devin.
And
I had another question. Devin, you can keep standing. This is with respect to the Delve contract. I wanted you to explain, I identified with you one of the provisions in the contract, and I'll just read it. The consultant, that would be Delve in this instance, agrees that the costs reported to the MSCA and Enbridge for this contract will represent only those items that are properly chargeable in accordance with this contract. Let's assume for a moment that there is an expenditure that Delve reports to us and to Enbridge, and that both we and the consultant have concluded that it is a properly chargeable expense under the contract, but Enbridge doesn't agree. Can you walk through what happens in that process that would be potentially delicate because the contractor is performing those services for us, but is being paid for those services by Enbridge?
Yeah, absolutely. And give a little bit of background before I get directly to that. So as Steve indicated, the current contract, it covers sort of the pre-construction phase. And as part of the contract, there's a scope of work included for what is currently been authorized. That scope of work was discussed with Enbridge. We, worked through that, made sure everybody was comfortable with that, and the same discussion will happen before the amendment with the scope of work for construction. And the hope is that all of those discussions prevent exactly that scenario. We've talked through all this. We all know what the IQA is going to be doing. Everybody's agreeing in advance. This is going to be the work. Enbridge is going to pay for it, and there aren't any disagreements. That being said, should there be a disagreement, it would fall under Article 14 of the Tunnel Agreement with respect to dispute resolution. That article essentially provides a multi-stage dispute resolution process, the first stage of which is an informal process in which designated representatives of Enbridge and the authority would engage in good faith efforts to resolve the dispute for up to 60 days, and that period could be extended if agreed to by the parties. After that, if we are unable to resolve the dispute, we can seek a mediator. Again, this would have to be agreed to by both parties. We would select a neutral mediator to try to facilitate the dispute. This would be non-binding. This would be purely voluntary mediation. Parties would share equally the cost of that mediator unless we agreed otherwise. And ultimately, if we still couldn't reach a resolution, the tunnel agreement then provides for a judicial dispute resolution process, and both parties, retain all of their legal remedies in terms of if we have to go to court over anything.
All right. Thanks. Any questions with respect to those contract updates? I don't see it. Oh, go ahead.
Yeah, no questions, just just stating that that dispute resolution process is listed in the contract, so.
And the other thing is this, to address this, to assign, because it's pretty item number 22 is pretty distinct, succinct, that it's MSCA approves the key people. So if we're going to include that as part of the approval, delegating that authority to
Okay.
the student
So
board.
this would be the appropriate point in the meeting to entertain a motion for approval of the IQA contract. Ruth, what I hear you saying, and I think it's an appropriate observation, is that the contract provides that it's the authority itself who approves of those members from Delve that actually perform the work, and that part of your motion to approve the contract also would delegate to the authority's project manager approval of those individuals at Delve that perform the work under the contract.
Yes, I think you've captured it correctly, that he would be delegated our authority to
Okay.
approve those key personnel. So yes, I concur and motion.
Okay, so it's been moved that the IQA contract be approved and that the board delegates to the project manager. The approval is contemplated, I think it's under paragraph 22.
22.
That the board delegates to the project manager approval of those entities or individuals within Delve that would be performing contract work for the authority. All in favor?
Aye.
Aye.
The contract is approved in that delegation along with it. The next item,
So the next one is just the approval of the pricing. So we need a pricing approval that we can expend those funds, and that way we'll finish the contract and we'll get that to you for the next meeting for the approval. So we just, with that number, we just wanted to make sure the board was okay with us going forward with that contract for the $593,681. That's, yeah, for the ORC, sorry.
okay.
Next item, yeah.
So there's a motion, if I understand it correctly, for approval on pricing of the ORC amount of $593,000.
Correct, for task order one, yep.
Someone like to make that motion?
I motion.
Okay,
To approve.
it's been moved to approve the $593,000 pricing on the ORC contract. All in favor, aye.
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 The motion is approved. The next item on the agenda is a modification or an update to the Special Assistant Attorney General's contract.
Thank you, Mr. Chairman. My current contract with the authority includes two other attorneys who assist me on this matter, John Loosley and Richie Patton. When Mr. Loosley started the project with me, he was my associate. Unfortunately for me, he has since been promoted to partner, and so he doesn't have as much time to assist me as he once did. And therefore, requesting an amendment to the contract to replace Mr. Loosley with a new associate, Bailey Cougar. Ms. Cougar has worked with me on a number of projects. I've been very impressed with her, believe she'll be an excellent addition to the project. The amendment does not increase the amount or duration of my contract. It only changes the attorney that can work with me on the matter, and I would just request approval of that amendment.
So your associate has all grown up and moved on, and now you need a new associate.
That's exactly correct.
All right. I'll entertain a motion for modification of the contract to contemplate the new associate.
Yes, so moved.
All in favor?
Aye.
Aye.
All right. Devin, does that modification require AG approval before we execute it?
No, I'll provide it to you today to execute. It has been sort of, it's gone through the
They've already-
administrative process. It still needs to be
Okay.
executed on their end, but they'll execute after you do.
Okay, thank you. The next item on the agenda are project specification updates. And we have Dr. Moody, who will be presenting via Teams.
Good morning, Chairman Novak, members Webb and Hepfer. Hope you can hear me okay. Just by way of background, the Joint Spec Committee for the Authority includes myself, Rick Liptak from MDOT, Steve Ward, who you met, Sam Schwartz from Delve Underground, and Talia Balil from MDOT. And soon, as you heard, Matt Schnellwith from RSNH will be replacing Delve Underground. We meet monthly, at least, with Enbridge, their designer, Arab, and their owner's engineer, WSP, to discuss any proposed changes to the project specifications. If those specifications are non-material, deemed to be non-material, and I'll just say that non-material means no negative impact to the future performance of the tunnel, then the committee has that approval authority as deemed by you, the board. We write a memo memorializing those changes. If the changes are deemed to be material, then we provide an opinion that comes to you, the board, for your consideration. In either case, all changes to the joint specifications are thoroughly documented and made available at each of the meetings where appropriate and to the public. So with that background, this last period since February has been a quiet period, I would say. There are no non-material changes that have been approved, and there are no material changes for which we have prepared an opinion on for your consideration. We are working through a few items with Enbridge and their team. These include radial bolt removal from the segments, which I did describe at the last meeting, and also curing temperatures for concrete segments. Those segments are built in a specialized manufacturing facility, and as the industries move to more supplementary cementitious materials, there's a desire and an ability to modify those curing temperatures. So we are working through those items. And I would think that at the next meeting, the August meeting, we will have a packet of information, whether non-material or material. With it, that's it. With that, I'm happy to take any questions.
Dr. Mooney, it's my understanding, and I'm not sure if this applies to the curing temperatures or just the changes to the precast concrete, but for one of those, additional testing is being performed to make a determination about the acceptability of the modification of the spec. Is that correct?
Well, maybe you're referring to curing temperature. So the discussions we are having with Enbridge is in the event where you increase curing temperature, then associated with that, a prudent approach would be to develop some performance-related testing to demonstrate that the increase in temperature is not causing any deleterious effects.
Okay. In any event,
certainly,
with respect to that item, you're
in
still
conversation
working through it before making a determination about the approval by the committee of that modification as an acceptable modification, non-material modification to the spec. Is that accurate?
I'm sorry, Chairman Novak, could you repeat that?
In any event, you're still working through whether the committee will approve that change in the specification as a non-material modification to the specification.
Yes, absolutely.
Okay.
We're still working through that. Yeah, absolutely.
Okay. Any other questions for Dr. Mooney? All right. Thank you.
Thank you.
The next item on the agenda is the receipt of Enbridge monthly reports. Stephen, did you want to speak to those or just reflect that they've been received?
Just wanted to make sure that they're in your packets, and we review those on a monthly basis, and we send them out to everyone. So unless there's questions about it, no, there's nothing that we haven't gone through all of those. Just
Okay.
want to make sure they're included in the packet.
The next agenda item is the next meeting, and we currently have it reflected as taking place on August 28th at 10 a.m. in St. Ignace.
Correct. And that one will be at the Little Bear Conference Center.
Okay. And that still works for, okay. All of the authority members, and then the November 20th one after that, which is contemplated to be held in Lansing.
Correct.
And that will be my last meeting.
Not that we're counting.
We're now at the public comment stage of the agenda. Do we have folks signed up for public comment, and if so, how many? Okay.
Oh, we have one.
No one signed up, but, or maybe they're signed up. In any event, come on up and speak if you'd like to.
And I will say that there were no written public comments on our
Okay.
website that we received during the last period. But come on up.
The agenda indicates that public comments are limited to 3 minutes, but given the number of public commenters, I don't think you have to feel so limited.
Well, it's interesting because I had 3 points and I gave myself a minute on each point, so I'll try to stick to that. And I apologize for not signing up because I arrived a little bit late. So the first thing is that I wanted to bring some information to you that I'm not.
I'm sorry, can you identify?
Oh, I'm sorry.
Your
Yeah.
name for the
So
record?
my name is Patrick Egan. I'm a resident.
Yep.
I'm a former journalist or continuing to be a journalist. I had the daily papers on both sides of the Straits for a number of years. And so I deal in information. I wanted to bring some information to you, to the authority that I'm not sure you're aware of, and that is that simultaneously as this project, huge project is going on, it's been reported that the Straits are in stress, that the fisheries biologists who've been studying the Straits have been telling us that whitefish are in danger, that they're in danger of collapse, that they are at between 95 to 100% fewer whitefish now than there were 10 years ago. So at the risk of tunnel vision, excuse the pun, I'm trying to expand your understanding of the situation. And while I understand that you are depending on Eagle and Public Service Commission, the Supreme Court to examine these sorts of things, I think it's important that you be aware that what is going to be happening with this industrial project for 5 to 6 years in the Straits, huge project, is not happening in a healthy environment. It's not happening in a Straits that looks good, but is not feeling good. So I think you need to have that understanding. The second thing that I wanted to ask you to do is that in the Corps of Engineers EIS, which you read, it was pretty devastating, the amount of harm and the amount of effect that there's going to be in this project. They talked a lot about the bedrock, and I refer you to 38.4, where they talk about the formations. One thing that they cite is that the Dundee Formation, which is the basis for the bridge, was not studied. That the Mackinac Breccia Foundation. And it was interesting, a couple of meetings ago, you had some native people here who talked to you about their long history with the collapse of Breccia around Turtle Island. So I would ask you to study not just the Mackinac Breccia Foundation, but to start looking at what possibilities there are that a collapse of that Mackinac Foundation might have on Dundee. Is it 0? Is it 2? Is it 10? And I would ask that you seek this understanding so that you understand that if there was ever any effect on the bridge where the foundation is on this Dundee Foundation, that's on the Corridor Authority. So I would ask you to take into consideration responsibility both for the tunnel and that you collaborate with the bridge so that the bridge feels insulated. Lastly, in discussing a lot of these sorts of things and in just the discussion recently about agreements, the quality assurance agreement, which we've had trouble with all along, which you share with Enbridge, how it's not a conflict of interest, and I appreciate your trying to separate responsibilities and try to understand how to bill separate responsibilities because that's what's happening. I would suggest to you, this is just me, that you consider getting your own attorneys, that you independently get attorneys, not Attorney General's attorneys, not depend on MDOT's attorneys because MDOT's attorneys are working for Enbridge, clearly, but that you get your own attorneys and consult on the possibilities of liability in the event that some of these things predicted in the Corps of Engineers and geological studies happen. So with that, thank you.
Thank you. Any other public comment? All right, with that, I'll entertain a motion to adjourn.
I so move.
All in favor? Aye. We are adjourned, and we'll be back in August.